Assembly Joint Resolution 113 relating to commending the ardent and remarkable service of Justice Anthony Scalia. Whereas Supreme Court Justice Anthony Scalia was born March 11, 1936 in Trenton, New Jersey, and passed away February 13, 2006. And whereas Justice Scalia championed the now widespread judiciary philosophy of originalism, whereas the meaning of the constitutional provision is set at the moment of ratification by the people. Justice Scalia educated, persuaded a generation of legal thinkers by originalism, and whereas Justice Scalia forever impacted the law of the United States of America by eloquently explaining his philosophy in countless judicial opinions, including a majority opinion in D.C. v. Heller and Prince v. United States, as well as his dissenting opinion in Planned Parenthood v. Casey, Atkins v. Virginia, Obergefell v. Hodges, and King v. Burwell. Now therefore be resolved by the Assembly that the Senate concurring that the members of the Wisconsin legislature commend the ardent and remarkable service Justice Anthony Scalia gave to his country throughout his fundamental belief in the rule of law for preserving the lasting consistency of our Constitution.
Perhaps the main hallmark of Justice Scalia's work is the judicial philosophy that he is credited with help bringing new life to. What he called a, quote, return to the oldest and most commonsensical interpretive principle. In their full context, words mean what they conveyed to reasonable people at the time they were written, unquote.
Certainly, the career of somebody who gave 30 years of service to the highest court in this land is worth commemorating. But this particular justice had a bit of distinction that I also think needs to be mentioned and acknowledged for people who have great concerns about his legacy. Most recently, arguing whether or not African Americans should attend lesser colleges than other colleges in an affirmative action case. Certainly, his words and messaging around marriage equality are deeply disturbing. His decisions about whether or not actual innocence should be a reason to stop an execution were deeply disturbing to many of us. And for all the heralding of his strict constructionalism and originalism, it seemed that he picked and chose when he would use that standard in big cases like Bush v. Gore when it suited his purpose. Mr. Speaker, members, I rise and will join in acknowledging the 30 years of service that this justice gave to this country. But I would be remiss if I didn't also acknowledge the harm that his words have caused to many of the people that I represent. Thank you.
There's been a request from the gentleman from the 5th for unanimous consent to have all members of the Assembly be added as a co-sponsor. Without objection, it's so ordered. We are on Assembly Joint Resolution 113. All those in favor of adoption will signify by saying aye. All those opposed will say nay. The ayes have it. We are honoring the late Chief Justice, or Associate Justice. The